The Constitution Act of 1982 is very important to you and I as individuals. It is the expression of our fundamental human rights and freedoms. It is the mechanism that exists in Canada that allows us as individuals to exercise our rights despite public law. We hear that law is for public good, and that individuals must sacrifice their rights and freedoms for the greater good of society. Before the creation of the Constitution Act of 1982, men and women did not have much ability to exercise their rights and freedoms. If an enactment removed an individual of a right or freedom, there was simply nothing much that they could do about it. R. versus Haynes. Prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state, beyond making representations to the executive or administrative arms of the government, or petitioning and lobbying Parliament or legislators for changes in the law, linked as they were to concepts of parliamentary supremacy and sovereignty. There were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. The law and the Constitution hinges the existence of public order, and it mandated compliance with directives and ordinances even if they infringed upon individual fundamental human rights and freedoms. So here, the Supreme Court of Canada is declaring and teaching us that prior to the advent of the Charter, prior to the Constitution Act of 1982, that an individual really had no basic means of protecting against incursions upon his fundamental human rights and freedoms. In fact, if an enactment or regulation stripped them of their fundamental right or common law right, it was expected of the individual to submit to that enactment anyways for the greater good, because law was for public order, and law, first and foremost back then, was for public order. That's why the individual was forced to submit. But since the Charter of 1982, this has changed. No longer is public order above fundamental rights and freedoms. So prior to the Constitution Act of 1982, an individual had no special means to protect against violations of their fundamental rights and freedoms. Public order demanded compliance with enactments, even if they were infringed upon by the individual, and fundamental rights and freedoms. The Charter changed this operation of law. No more was the public order the priority concerning rights. If an individual was infringed or denied their fundamental rights and freedoms through domestic law, the individual was now empowered to challenge the infringement or denial of the right. Now, this operation of law only came into existence in 1982 through the Constitution Act of Canada. The Constitution is the ground law, the fundamental law of Canada. It is a very important document of law concerning our fundamental rights and freedoms. The Constitution restricts and controls how the government must treat you. If the government fails to honor your fundamental rights and freedoms, the Constitution protects you. It gives you the power to stand up and say, "No, I'm not giving up my natural rights. No, I'm not surrendering my fundamental rights and freedoms." In Canada, we have many types of laws. We have enactments, we have regulations, we have codes, like the Criminal Code, etc. The Constitution Act of 1982 is the supreme law of Canada. So you see, when you look in the Constitution Act of 1982, you find the following. It states the Constitution Act of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Now, when you look at another judgment, at PPG Industries Canada Limited versus the Attorney General of Canada, it states that it is clear that the Constitution Act is not subject to the Interpretation Act. So for those who are looking through laws of Canada and looking through their freedoms, they come across the Interpretation Act and they find the redefinition of the word person in there. Well, here it states that the Interpretation Act is not subject to the Constitution Act. Or excuse me, vice versa. So therefore, that redefinition of the word person is not applicable on the Constitution Act. Now, the Constitution Act, which is the supreme law of Canada, is a direct expression of the rights and freedoms found in the international covenants, better known as the Bill on Human Rights. This Constitution was something that Canada was forced to create due to their obligations to the international covenants. Now, when you look in the international covenant itself, in Article 2.2, now this is the International Covenant on Civil and Political Rights, you find the following: where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So Canada, as a state party, had to produce a new constitution here and had to follow the provisions of the covenant and had to give effect to the rights that were recognized in the covenant. Now, the Constitution is the supreme law. It's an expression of international law. It protects and ensures fundamental rights and freedoms here in Canada. And the Constitution Act is above all domestic law, all enactments and regulations. Now, in R versus Hape, this is another Supreme Court judgment. It says the Constitution Act has brought forth the rights and freedoms guaranteed and expressed in the covenant in accordance with the provisions of the covenant. The Constitution of Canada is the power that can and must be used by an individual to invoke and exercise their rights and freedoms. The executive powers of Canada are bound to follow this Constitution Act, and if they do not, then they are in dishonor of their obligations. Many are seeking their rights and freedoms, and on their journey they have been led to believe that the common law was the way to seek freedom. They are led to believe in administrative judgments and commercial liens. This is a straw man argument and is nothing but a falsehood. We just saw above that prior to the Constitution, common law was not enforceable to any important degree. Since the inception of the Constitution, common law must be expressed or claimed through the Constitution itself. Now look, the Supreme Court of Canada wrote in M versus Ryan that common law must develop in accordance with the Charter values. A trespass in common law equals an infringement or denial of a fundamental right listed in the Constitution Act or the covenants themselves. So this is very clear. Now, in 2015, when I'm making this video, in order for you to call upon a common law breach, you have to produce the breach, or you have to produce the restriction of the right through the Charter. You have to show that this common law right was enshrined in the Charter, was enshrined in the Bill of Rights, and you're restricting this right. And you have the obligation to ensure and protect the right, not to restrict my right and to remove it. The Constitution Act of 1982 in Article 32, it states that the Charter applies to the Parliament and Government of Canada in respect of all matter within the authority of Parliament, and the Charter applies to the legislators and the government of each province. This is bringing forth the fact that the ones who make laws in Canada are under obligation to follow the rights and freedoms that are ensured and protected in the Constitution. If they create laws that violate our fundamental rights and freedoms, then these laws are of no force or effect against us. If we see and understand that a law they are claiming we have a duty and obligation to is against our rights as ensured in the Constitution Act, we can claim that they are no force or effect against us. The government creates laws. These are called enactments and regulations. However, they must create laws that follow the Constitution. If these laws violate the Constitution, we have no obligation to obey. Article 52, again, of the Constitution states, the Constitution of Canada is the supreme law of Canada, and any law, any enactment or regulation that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force or effect. The Constitution Act of 1982 guarantees the rights and freedoms set forth in it. These rights and freedoms are expressed or are an expression of our fundamental human rights and freedoms, which are coming from international covenants. The word that is used is guarantees. They can say this because despite any public law, despite any enactment, our rights and freedoms as human beings, as men and women, remain intact. Remember, we just read in the opening of this video how prior to the Charter, public law reigned, and it was expected of man and women to submit to public law, to submit to the enactments and regulations. However, since the Charter, since the conception of the Constitution Act of 1982, now individuals like you and I have the right to say, your public law is stripping me of my fundamental right and freedom. Your public law is trying to remove my natural right and freedom. Therefore, it is of no force or effect against me. The Constitution Act of Canada 1982, Article 1 states, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it. The Constitution is the supreme law. It guarantees the rights and freedoms. It is an expression of international law. This statement here creates the liability and obligation upon the state party Canada. This is a legal obligation. The Charter guarantees the rights and freedoms. These fundamental human rights and freedoms that are expressed in international law and subsequently enumerated and ensured in domestic law are guaranteed for an individual to exercise. What we must be aware of is that not all of the international obligations to express fundamental rights and freedoms that Canada had to fulfill were placed in the Constitution. So, remember, they had the obligation to transfer all the rights out of the International Bill on Human Rights into the Constitution. But they didn't do that. They transferred the majority of them, but they left some of them not directly mentioned in the Constitution. But listen to this law here that we find in the Constitution Act. Constitution Act of Canada, 1982, Article 26. The guarantee in this charter of certain rights and freedoms, you see they qualify it, shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. So if you can find fundamental rights and freedoms, common law, natural law, that exist within the International Bill on Human Rights that is not directly transferred into the Constitution Act of Canada, then you can call on Article 26 of the Constitution Act that says even though this Constitution is naming certain rights and freedoms, you cannot deny that there existence of other rights and freedoms that are existing here in Canada. It allows you to bring over those rights and freedoms here into Canada. The guarantee in this charter of certain rights and freedoms. This is a qualification, bringing forth the fact that the Constitution Act only brings forth certain rights and freedoms directly. However, even though the Charter only guarantees certain rights, it does not mean that Canada will deny the existence of other international human rights and freedoms. Constitution Act of 1982 guarantees certain fundamental human rights and freedoms directly, produces legal obligations on Her Majesty, does not deny other international rights and freedoms. Article 26 of the Constitution allows an individual to call on fundamental rights and freedoms listed and enumerated directly in the international covenants. Canada is not allowed to deny the existence of our international human rights and freedoms, even though they may not be directly listed in the Constitution Act. There are many rights and freedoms that were directly transferred into the Constitution Act from the international covenants. Again, this was done because Canada, more specifically Her Majesty, was bound internationally to do so. Let us look at some of these certain rights and freedoms that were directly transferred into the Constitution from international law to further see this mechanism of obligation in operation. So we look at the International Covenant on Civil and Political Rights in Article 22, and it says, everyone shall have the right to freedom of association with others. We have the right to decide who we will associate with. This is a fundamental right that is expressed in the international covenants. Well, when we look in the Constitution Act of Canada 1982, in Article 2, we find the same thing stated. Everyone has the right to freedom of association. So what are you seeing here? You're seeing the obligation come out internationally, and then you're seeing Canada express it domestically through their Constitution Act. And remember, I'm going to scroll up here. In Article 2.2, of the International Covenant, it taught us and it stated that Canada had the obligation to transfer these laws out of the International Covenant into domestic law. You see, we're not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. And now we're seeing it. So the covenant said that everyone has the right to freedom of association, and now we saw Canada transferred that right in the Constitution Act in Article 2, where it says everyone has the right to freedom of association. Now let us look at other rights in the International Covenant on Civil and Political Rights, Article 18. Everyone shall have the right to freedom of thought, conscience, and religion. Now we look to the Constitution Act of Canada, 1982, Article 2. Again, everyone has the following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, and opinion. International Covenant on Civil and Political Rights, Article 19. Everyone shall have the right to hold opinions without interference. And everyone shall have the right to peaceful assembly shall be recognized. Now in the Constitution Act of Canada, Article 2, everyone has the following fundamental freedoms: freedom of opinion and expression, and freedom of peaceful assembly. So all these laws that are in operation in Canada did not originate from Canada. They are simply fulfilling their obligation to international laws. These rights and freedoms were initially brought forth in the international covenants and then subsequently expressed in domestic law and in the Constitution Act. We can also proclaim with certainty and without doubt that fundamental human rights and freedoms are the supreme rights and freedoms that exist in Canada. This state party must guarantee these rights, and if any law tries to remove these rights and freedoms, they are of no force or effect. The Constitution Act